Have you ever wondered where the concept of cross-examination in a court of law comes from? What forces shape this quintessential element of modern trials? Today we delve into the rich history and evolution of cross-examination. Imagine a time when trials were more of a spectacle, a performance, rather than the calculated and orderly proceedings we're accustomed to today. This was the reality in the courts of ancient Greece, where the seeds of cross-examination were first sown. The Greeks valued rhetoric and persuasion, and their courts were places where orators showcased their skills. It was here, in the public trials of Athens, that the practice of questioning one's opponent began. Fast forward to the Roman Empire, where legal proceedings took a more systematic form. The Romans, known for their meticulous attention to order and detail, introduced the concept of interrogatio, where a litigant could question a witness directly. This was a crucial step toward the development of cross-examination as we know it. As we move into the Middle Ages, the legal process changes yet again. Trials by ordeal were common, and the idea of cross-examining a witness was almost non-existent. However, the seeds planted by the Greeks and Romans would not remain dormant for long. With the Renaissance came a renewed interest in the legal practices of the ancient world. The adversarial system, where two sides present their case before an impartial judge, began to take shape. The idea of cross-examination, of testing evidence through rigorous questioning, found its place in this system. As we cross the Atlantic and step into the New World, we see the concept of cross-examination firmly entrenched in the legal proceedings of the colonies. The Salem witch trials of the late 17th century, for instance, saw the use of cross-examination to challenge the credibility of witnesses. The founding fathers of the United States, drawing from their English roots and their own experiences, ensured that cross-examination was enshrined in the Constitution. The Sixth Amendment guarantees the right of an accused in a criminal prosecution to be confronted with the witnesses against him, laying the foundation for the practice of cross-examination in modern American trials. Fast forward to today, and cross-examination is a cornerstone of legal practice. It's a tool to challenge evidence, to test the veracity of a witness's account, and to ensure that justice is served. So, what have we learned? Cross-examination, as we know it today, is a product of centuries of evolution. It began in the courts of ancient Greece, was refined by the Romans, lay dormant during the Middle Ages, was revitalized in the Renaissance, and was finally enshrined in the Constitution of the United States. Remember, it's not just a legal mechanism. It's a testament to our commitment to justice, to the belief that truth emerges when opposing viewpoints are allowed to clash in a fair and open forum. It's a reminder of our historical journey and the continuous evolution of our legal system. The history of cross-examination is a fascinating journey, a testament to our eternal quest for truth and justice. It's a journey that continues to evolve, shaping the trials of today and the future.